Hello, everyone, and welcome to another episode of Women Winning Wednesdays. I'm your host, Attorney Elsa W. Smith, your Maryland estate planning attorney, and I'm the owner of the law offices of Elsa W. Smith, where our mission is to empower women through estate planning. Through our guests and educational content, my hope is to provide you with glimpses of what an empowered woman is and the tools that she needs to win. Today's topic is estate planning through the 4 stages of life. Each stage of life has different requirements and I'd say must-haves when it comes to estate planning. The stages of life I'm going to talk to you about today are young adulthood, marriage and family, midlife, and retirement. Now, before I get the comments, let me say that I know very well that life doesn't happen the way that I'm mapping it out here. People choose not to marry. People choose not to have children. People divorce and remarry, not just once, but multiple times. I break things down into these phases merely for convenience and just to ease of explanation. They reflect a more traditional path, but I am very cognizant that life doesn't always happen in this sequence. Before I start, though, I want to share my story and why I'm so passionate about estate planning. You see, I didn't always have an estate plan. My parents did the best that they could, but they didn't know and therefore couldn't advise me that I should have certain documents when, say, I went off to college. And then when I was living on my own, after law school, I created my first estate plan when I got married over 14 years ago. I remember the feeling of having my portfolio in front of me and thinking, wow, it's like now I feel like a grown up. I remember the feeling of empowerment. And that was the seed that led me years later to focus my law practice on empowering women through estate planning. I shared that with you because one, I need you to understand that it's never too late to get started. And two, I don't want you to beat yourself up for not knowing what you didn't know. My hope is that you get something from this episode that lights a spark and that you finally get it. It won't happen for everyone in this episode. I know. You may have to listen to this show more than once. You may have to go to my YouTube channel and maybe watch other videos. You may have to attend one of my webinars before that spark is lit. My hope, though, is that the spark happens sooner rather than later. Now let's get started. The 4 stages of life. We're going to start with young adulthood. Let me get that one. There we go. Now, as a young adult, we feel invincible, right? But it never hurts to have some things planned just in case. You don't expect to, wreck your car when you're a young adult, but you do carry auto insurance. The same could be said for health insurance. You don't expect to get sick, but you want to protect yourself just in case. And too many of us know the tragedy of a promising young life that was abruptly cut short. To the parents that are listening, once a child reaches the legal age of adulthood, parents lose the legal ability to make decisions for that child or even to find out basic information. I still talk to parents and they're shocked that this could be so. But learning that you're not going to be able to see, say, your students like college grades without their permission can be a bit frustrating, particularly if you're the one paying the bill. But in a medical emergency, the not knowing, the not having access is going to amp up that frustration that you have to a completely different level. The parents, or maybe a sibling or another person, will probably have to go to court and ask for permission to obtain information about that student's medical condition, if we're talking about the college student scenario, and make decisions about their treatment and have access to that, to that student's financial records and accounts, and say, and this is a situation where that student is, say, unable to speak or and make decisions, healthcare decisions, even on their own. All right. One of the documents that a young person should have is a will. Young adults should consider putting a plan in place that determines the disposition of assets upon their death. Now, if a person dies without a will, that's known as dying intestate. You all who follow me know or are now familiar with that word through prior videos and other blogs that I've written about. So dying intestate, assets are going to be distributed accordance with your state's applicable law. Now, in many cases, a simple will may be enough to just state your wishes. But keep in mind that a simple will may not be, it's not going to be enough to keep your estate from going through the probate process. If a person dies testate, that is with a will, pardon me, that same young person could choose to have their assets distributed to their sibling who, is burdened with student and maybe even credit card debt, as opposed to their parents who are enjoying a well-earned retirement and are sipping a cocktail on the beach. So different financial situations. Or say if a young adult has two siblings and one of them is responsible and the other is reckless. Now, if there's a will in place and the parents are deceased, the individual, that young person's assets will likely be divided equally between the two siblings. And in all likelihood, that young adult probably doesn't want the sibling who is challenged with making good decisions to have, a lot of their assets easily accessible. If they're inheriting, say, a bit of money. A will is going to allow an individual to appoint what's called a personal representative, also known as an executor, to administer that estate. And naming a person in a will can minimize future disagreements among family members. For example, divorced parents who each then want to serve as personal representative of their deceased child's estate. Other documents that a young adult should consider having is a power of attorney and advance directive. After turning 18, young adults should execute a power of attorney and an advance directive. This is particularly important for students who are going off to college. I referenced that earlier. That power of attorney is going to appoint what's known as an attorney in fact, to make financial decisions in the event of their incapacity. An advance directive will appoint an agent to make healthcare decisions under the same circumstances. In the event that the college student or young adult is hospitalized, doctors will only communicate with a parent or other individual if an advance directive names them as the agent. The healthcare directive makes sure that it also has a HIPAA authorization so that a hospital can share your private health information with that agent when necessary. So in similarly, if a young adult is incapacitated and unable to make financial decisions, a parent or someone else that's named as agent will only be able to access accounts to pay bills, for example, and transact financial affairs if a power of attorney of a durable power of attorney is in place. So now we finished with with young adulthood, and I've touched on like a few of the documents that I think are just basic that they should have. Now let's transition over to marriage and family. Starting a family is an important and often overlooked time to get estate plans done. When you get married, it's likely that you'll want to redesignate both your financial and healthcare or advanced directive agents. You probably want to assign that responsibility to your spouse. You also want to consider how those assets are controlled and directed now that you are married. Okay. Here's a tip: review your insurance policies, particularly life insurance. Many couples marry early in their careers with the majority of their earning years, way ahead of them. So both spouses also make substantial contributions to household finances. If something were to happen to either one, the surviving spouse could be left in a difficult financial situation. Therefore, it makes sense for couples to think about and decide whether they need life insurance, whether they're going to self-fund, now that they are depending on one another. Would also be a good time to buy, if you're going to buy a policy, to buy it while you're healthy and still in a lower age bracket. The other thing you want to consider, again, just like young adults, is we return to the wills. Most newlywed couples enter a marriage without an estate plan or a will. Now, even if you do come into the marriage with a will, it's important to update it now to include your new spouse. In drafting wills, it's an important part of financial planning, and it can help couples make important decisions, such as determining who should be the personal representative, and how assets should be distributed now that you are married. So comprehensive estate planning is going to also cover arrangements for children, such as naming a guardian, establishing trusts to delay an inheritance until that child reaches the age of maturity. You could even make plans for your pets. And drafting a will and getting one drafted doesn't have to be time consuming. When you work with an attorney that understands the pressures facing young couples, you can save time and money while receiving quality advice that's relevant to your particular situation. Again, still under the marriage and family stage of life, prepare those powers of attorney and healthcare directives. Along with wills, an estate plan should include these two. The forms designate, again, who you want to act on your behalf when you're not able to. A power of attorney is used to make financial decisions. Healthcare directive, advanced directives are used to make medical decisions. Newlyweds should identify who should act as a backup if they can't act for each other. Say they're both away on vacation or on holiday, as my friends in London say. If they're away, then who's the backup if something goes wrong? If one of them has to go into the hospital. Getting these forms completed along with wills should be a foundation of a sound estate plan. Next thing that couples want to think about are beneficiary designations. You'll hear me mention this often in videos and just other writings that I do, update those beneficiary designations. With all the commotion of preparing for a wedding and starting life as a newlywed, it can really get easy to forget to update those beneficiary designations. And if any of my clients or former clients are listening, they know that I'm always harping on updating those beneficiary designations. For many people, though, this is one of the common ways that they can pass assets to their surviving spouse. And each spouse needs to review their financial accounts, including 401ks, IRAs, brokerage accounts, bank accounts, for my government folks, the thrift savings plans, your TSPs, and update the beneficiaries as needed. Right? If the couple wants to make sure that all the assets pass to the other spouse, if one of them should die, they should designate each other as the primary beneficiary on their financial accounts. This is really important because those beneficiary designations, they take precedence over what you write in a will, what you designate in a will. They will always take precedence. Another thing young families should think about is, retitling real estate. Say if either spouse owned a house or other real estate before their marriage, they should consider whether they want that property to be jointly owned by them. For example, if one of the spouse owned a home owned the home that the couple is now going to be living in, they may want the property now to be titled in both names. They can do this by, executing a deed, placing the property into, say, a joint tenancy with right of survivorship. That way, both spouses will have the rights to the property, and the surviving spouse will automatically inherit the property if one of them should pass away, if one of them should die. So, in this phase, documents that say a young family should think about is having a more complex will, and that includes a testamentary trust, perhaps to protect your minor children. You want to name guardians. You want to make sure that you have the correct transfer on death designations on bank accounts. Think about life insurance, as we talked about, with the proper beneficiary designations. Make sure you have those healthcare directives, and have those financial powers of attorney naming your spouse if that is what you choose. But if it is, make sure that the documents reflect that. And another thing, make sure that you make a list of all your online accounts and passwords. Those are really handy. Say if you're in the hospital and your spouse needs to access some of your accounts for whatever reason, it's just helpful to have a list of those accounts and those passwords handy. So now we're going to move on to midlife. Okay. Once you hit middle age, and people are like, well, what's middle age? Because people are living longer. But if you're pretty much at the halfway point, women, yes, we are living longer. We, thanks to medical, technologies, we are, living well into our 70s, 80s, 90s. I've seen some drop dead gorgeous women, who are 90 and are just living right. So midlife, okay, whatever that means to you. Once you hit middle age, you're going to want to start focusing on steps to retire comfortably, right? Now, for many people, their children are grown. If they have children, they're grown and they've gone through college and they're starting families of their own. And many people reach mid life, however, having done no estate planning, right? Even those who maybe did plan in their younger years may have a plan that's outdated or not appropriate. okay, now that the children are grown. If you have one, it's time yet again to take a look at your estate plan. This is the time that I think, most people should at least consider a trust. A living trust avoids probate and offers a much more comprehensive plan than, say, a simple will. Now, everyone's priorities and needs may differ. So, again, I say a trust is something to consider among the various estate planning tools out there. An estate planning attorney can explain whether a trust and what type of trust is right for your particular situation. Estate planning in the middle of your life, or your retirement years often involves coordinating the will or your trust, if you have a trust, with beneficiary designations on your retirement accounts. Again, the IRAs, the 401ks, the TSPs, etc. And many people are unaware that these accounts do not pass through your will or trust at death, unless you've named, excuse me, they don't typically do. They're relying on the beneficiary designations. Planning in midlife can also involve income planning. Income planning, let me reiterate that, for a surviving spouse in the event of the death of the spouse, with a larger Social Security payment. Midlife planning can also or should also address funding for long-term care in the home or elsewhere, or in protection of assets if home care becomes impossible and nursing home care is needed. I can tell you that the cost of long-term care policies have increased exponentially. It's increasingly more difficult to get long-term care, particularly the older that you are. So if you can start off, even as a young family, at least start having the conversations and explore long-term care and the cost of it early on, because I tell you that the longer that you wait, the more expensive that it will become, and I don't see them getting any less expensive. Again, think about long-term care insurance. It's better to do it earlier rather than later. The kind of coverage, or LTC is the acronym, the coverage is going to protect you if it's ever necessary for you to go into an assisted living situation. So in midlife, what are the documents again? Just to review, you want to consider a living trust-based plan with the accompanying pour over will for each spouse. Retooling, retitling real estate deeds in order to avoid probate if this is applicable to your situation. Make sure that your beneficiary designations on your bank accounts are up to date. Consider life insurance with the proper beneficiary designations. Make sure that you and your spouse, your partner, have a healthcare directive, and that you both have financial powers of attorney. And again, the reminder to have that list of online accounts and passwords handy. And then finally, we reach the retirement phase. You may not, if you're in retirement, you may not want to think about estate planning, but it is so important. There are many benefits to doing so, but the main one is keeping the peace within your family, right? Now, most of us can recall an instance of, family drama as the result of a person who's deceased, not having a plan, right? Yeah, exactly. Major drama. It's so avoidable. And being intentional with your estate planning is a gift to your loved ones. I say that, an estate plan is a love letter to your family. Planning not only benefits them, but it can provide a great deal of peace of mind to you as well. At a minimum, your estate plan should include a will, a power of attorney, a health directive, advance directive, and as they are needed by everyone, regardless of financial situation. In the case of dying intestate, again, that word, it means dying without a will. The courts are going to have to appoint a personal representative and distribute those assets and possessions according to state law rather than your wishes. Right? Once you get those essential documents, again, that's at like a bare minimum. Once you get those created, you should review them every 2 to 3 years, or sooner if there's a major life event that has occurred. For example, a birth, a death, divorce, remarriage, adoption, just to name a few, and determine if changes need to be made. I also recommend revisiting the documents anytime, estate laws in your state have changed, um, as your estate plan could be significantly impacted. It could have impacts to your overall plan. Evaluate the beneficiaries you have named as to their own stage in life, and consider whether receiving an inheritance from you, in a large, like a lump sum payment, is the best choice for that beneficiary. What brings to mind is an example I was speaking to a colleague about the other day is bequeathing someone a large sum of money, and if they're, say, in a lower tax bracket, and receiving just boom, a lump sum of cash all at once, that may have negative tax consequences for that individual. Again, that's something that you'd want to consult a tax professional about. But always keep in mind, and also think about that person's habits. I mean, are they a responsible person? Do they have addiction issues? Are they receiving disability payments? And as I said, they consider whether they have bad spending habits, or are they perhaps in a troubled marriage where receiving that lump sum of money can create more problems than, if you hadn't left anything to them at all. Again, lots of considerations. Every family dynamic is different. Trust me, I've seen quite a bit, but that's something that an estate planning attorney can help you work through. In retirement, you want to re-examine your medical directives. Have you changed your mind about the circumstances you want to refuse life supporting measures? If you had, say, an advanced directive that's like 15, 17 years old, your opinions might have changed. This is especially important because of the COVID pandemic, and more widespread use of, ventilators. Do your legal documents reflect your current wishes? Is the right person appointed to advocate, to speak for you and advocate for those wishes if you are unable to? People's relationships change. Sometimes people grow distant, sometimes they sour for whatever reason, and that person may not be the best fit. That's putting it diplomatically. May not be the best fit for you anymore. They may have been, say, 15 years ago, but now your situations have changed. And consider who your personal property should go to. Dividing money between children, yeah, it's usually pretty easy. However, it gets trickier when you're thinking about personal property. Who gets the diamond ring? Who gets the art collection? Or who gets the sorority paraphernalia? That can cause some dispute between heirs if there isn't a plan ahead of time as to who gets what. One approach that I've seen is perhaps taking pictures of certain items and kind of writing down who they should be given to upon your death, and kind of have that ready when you're going to meet with your estate planning attorney to craft your plan. Again, if you don't have one already. A former client had, she hosted kind of like a family day where, and she had three adult children. She invited them over to her home, and they each had color coded post-it notes. And each one of the children were, they were to go throughout the house and basically tag what items they particularly wanted for themselves. And if there was a dispute, the siblings had to work it out that day, amongst themselves. So kind of fun. It gets all the engagement among the family members, and again, it minimizes the family drama. I thought that was a pretty creative way when she shared it with me. So I'm sharing that with you. So in retirement, you're going to hear me say a lot of the documents that you should have, I've mentioned, from earlier phases of your life. So what are they? A living trust-based plan. If you have a living trust, then the pour over will for each spouse. Real estate deeds, titled appropriately in order to avoid probate. The correct transfer on death designations on bank accounts. Life insurance, if it's appropriate, with the proper beneficiary designations. And if you choose not to have life insurance, then are you going to self-fund? And if so, where are those monies going to be housed? Consider a healthcare directive for each spouse, a financial power of attorney for each spouse, personal property distribution. Make a list, have it handy so that when you go to the estate planning attorney, it's easy to just put that all into your estate plan. And then lastly, a funeral directive. Yes, there's some overlap, as I mentioned before. There are some documents that may be appropriate to have earlier in life. It all depends on your situation. I've always said that estate planning is not cookie cutter. We have to meet with you, gather information about your financial situation, what your hopes and what your dreams are, and a whole lot more. It's kind of like going to the doctor. But listen, you don't have to figure all of this out alone. An experienced estate planning attorney like myself can assist you to reduce that overwhelm. I hope that you have found this episode informative. Get it on the replay it, take notes. Again, this is just an outline of like what documents you should have, what you should be thinking about at different stages of your life. I want to thank you so much for tuning into this episode of Women Winning Wednesdays. If you need assistance with estate planning matters in Maryland or the District of Columbia, and you want to have a strategy session, let's talk. Give us a call. Reach out to us. You've seen our information there on the ticker screen or whatever roller at the bottom of the screen. But give us a call. I want you also to get our free estate planning jumpstart guide. Again, as I said, it's free, it's a resource, but I think it's really going to help you get the ball rolling. Go to my website, elsawsmithlaw.com. Go to the resources tab, and in the drop down, you'll see the jumpstart guide. Get it, download it, use it, share it with a friend. And let's get your estate plans done or updated if necessary, very, very soon as possible. Thank you again for tuning in. I'm Attorney Elsa W. Smith, your Maryland estate planning attorney, empowering women through estate planning. Thanks so much for watching, and I will see you in my next episode. Be well, everyone.